I'm now hearing 242158. That's Mary Grace Knopf versus James Nathan Matthews. Do I have someone here on behalf of Mary Grace Knopf?
Yes, Your Honor. I'm Mary Grace. Good afternoon.
Good afternoon, ma'am. Thank you for your patience. We've not
Sure.
had anyone arrive on behalf of the defendant, but is there anyone at all here on behalf of James Nathan Matthews? No. All right. We will mark that as a no-show, and then let's take a look here. Ms. Knopf, how much were you seeking against the defendant?
Currently, I'm seeking $16,000, $16,388 from the defendant.
And what is that for?
So it's been some time since I originally filed for this case to get a hearing. So since that time, I was actually able to well, let me go back in time. The loan balance of the contract that we had in place was 26,388. I'm in small claims court. I understand that it's only $20,000. I did not have enough money to get an attorney, so I was happy to.
Ms. Knopf, then I'm going to stop you right there, and I want to give you some information because that may change what you're going to do here.
Okay.
Texas does not allow you to what's called cram down. If you're owed more than $20,000, you can't take it less by coming to me because you can't afford it. In fact, you can sue for free with an affidavit of inability.
Okay.
And so what I'm going to tell you to do, which is not advice, it's information, is you may wish to continue today and go and research your claim about how to better file it. Because if what you're telling me is, Judge, he owes me 40 and I'll just take 20, even if it's true, and I don't disbelieve you, I'm legally not allowed to do that. That's considered a cram down, and they only want justice court to handle cases which truly have a jurisdiction of 20,000 or less.
Got
If
it.
your claim is absolutely beyond that, you cannot be in our court. There are ways for you to get where you need to go, even if what you're saying is that I'm already harmed and out the money. I don't have the money to go over that forth. There is a method to do that. There are other ways you might pursue it in a court like mine. I can't tell you how that is, and I don't know all the facts of your case. I just say that there's more to it. But the idea that, well, I will accept less that's illegal in Texas.
Understood. Things have changed since I initially had to repossess the truck. Um, and there's other facts that, of course, we
So
can
then let me ask
discuss
you
that
this, Ms. Knopf. Was the loan for him to purchase a vehicle?
correct for his
Did you
business.
co-sign for him to buy a car?
The loan was in solely my name only we were together, living together in a romantic relationship at the time.
Let
So
me
the
ask you
loan
this.
was
Was
in
it actually a loan, or did you just finance a car in your name and let him drive it?
It was a financed loan through Wells Fargo for him to,
But
sorry, for him to
did
drive
you
for his
sign a
business.
written contract with him for a loan, is what I'm trying to get at? Or did you just, he was supposed to be paying you back?
Initially, there was no contract until a year and a half later between him and I after we broke up and he would not return the vehicle to me. So initially, it was a verbal agreement because we were together, we were living together. So
All right.
the truck was purchased with down payment. Everything is in my name, the title, the contract, as well as the loan for $45,000 initially. The agreement between the two of us was he was going to make monthly payments for $807 and take over the loan as soon as humanly possible once his new business became up and running. Then I would transfer the title to him once he took over the loan. That obviously did not happen. We broke up a year later in 2022, April 22. At that time, we still did not have the signed contract. That did not take place until 23 because he refused to take over the loan and refused to return the truck to me for possible resale and refused to tell me where it was.
What were the terms of the contract that you signed in 2023?
What were the terms?
Yeah.
So the terms were, well, there were multiple terms, but the truck specifically was that he was to make the monthly payments. It was 807 and 11 cents on I think it was the 8th or the 9th of every month, and that he had 6 months from that date of August 24th, 23, which would have been February 24th, 24, to buy the truck in full or refinance, get a new loan so that I can title the transfer to his name. That clearly did not happen either.
All right. Under
So
the contract, did you exercise your right to repossess it?
I
Because what was
don't
it in the
think,
contract? So in the contract, you said there were a lot of things. You said, I'm going to
yes,
pay 807 a month, which he'd already said he was going to do. And he said, I'm going to make sure I get it out of your name within 6 months. In your contract that y'all wrote, was there a consequence to it if he didn't do those things?
I'm refreshing right now. Payment terms, pay the remaining balance to own the truck. Borrower has the option to make higher monthly payments over the course of 6 months. I do not have anything about repossessing in
What
writing in
happened?
this.
So what was did you have any rights if he didn't do it again, right? So y'all broken up, you've signed a contract. It says he's going to pay. If he doesn't do it in 6 months, then what was the consequence if he didn't refinance it in 6 months? Just that he didn't do it, or was there something you got out of that?
It was either to return it to me so that I could sell it and make a,
Repossession. There you go.
yes, yes.
Okay. So did he pay 807 every month after y'all signed that contract?
He did for a period of time. There were many
So
months.
no, at some point he stopped paying 807.
Correct, correct.
Okay. And did you repossess the car at some point
Yes,
after he stopped making payments?
yes. I at
And have you
first,
sold that car?
yes, I did send him a demand letter first to do things the proper way to give him the opportunity. I gave him multiple options because,
That's great. You didn't have to give him shit. If he didn't
okay,
pay, you can go get the car, right? That's Texas law. The
correct.
minute someone misses a car payment into law, you can go and repossess it. You got the car. My question is, did you sell it? And if so, what is the outstanding balance on the loan?
Yes. So I was able to repossess it. It cost me an arm and a leg. That's obviously, I'm not including that in this case. I took me so it was discovered broke down on the side of the road in horrible condition. The engine was completely blown. All the tires were blown. It had moldy. The doors were left open. It looked like a homeless person had been living out of it. So luckily, I was able to work with a company called Discount Diesel that specializes in these types of trucks. It took me 8 months, but I was able to, I didn't have any money to fix the engine. I did offer him to pay to fix the engine so he wouldn't have to pay as much. I did end up selling the truck about 8 months later for $10,000 broken. So that's why I'm asking for 16,388, which is the $26,000 left on the loan minus the 10,000.
That is definitely within my jurisdiction then.
Okay.
That absolutely gets you where you want to go. Cool.
I
All
should have led
right.
with that. I've never done this
No, no,
before.
no. You're doing just fine. Miss Snuff, I also, first off, I went to school for this. I went to extra school for this. I decided to get elected for this, and then I do it all day. So for me, when I hear these, I'm like, okay, I'm looking for these kind of elements. But you're absolutely right. All of those things happened. And the story about how it came to be, not at all uncommon. I've heard this a lot. But I kind of like, all right, in order for you to have a legal claim, I'm looking for things. And yep, you just hit it entirely. So Ms. Knopf, let me go ahead and swear you in, and I'm going to recite your testimony. Let's make sure these things are accurate. If you'll raise your right hand for me. Do you understand you're now being sworn to tell the truth, the whole truth, and nothing but the truth under a penalty of perjury? Do you so swear?
Yes, I swear.
All right, you can put your hand down. Ms. Knopf, is it correct that you procured a loan in your name on behalf of your then, a person you were then in a relationship, the defendant, James N. Matthews?
Yes.
And after that loan was made, Mr. Matthews exercised control and possession of the vehicle and made payments on it in some reasonably regular method until you broke up in April of 2022. Is that
Yes,
correct?
correct.
All right. And then thereafter, he continued to make some payments and y'all worked this out. But eventually, parties agreed to a contract, a promissory note that was signed in 2023.
Correct. Yes.
And this is that signed contract between the parties, an agreement between Mary Grace Knopf and James Nathan Matthews for loan and debt.
Yes, correct.
Okay. And I can indicate in here, it tells me that the combination of those loans that y'all had out, about the debt that was to be repaid, about payment in terms, supposed to be taken care of, gonna get it done in 6 months. I see that here. And Ms. Knopf, it's your testimony that Mr. Matthews did not complete the terms of the contract that was struck between the two parties.
Yes, correct.
In fact, he breached the contract by not making all the payments and by not refinancing into his name within 6 months.
Yes, correct.
As a result of this breach, you exercised your rights and you repossessed the vehicle. You found it in a not great state, but you then did sell that vehicle and recouped $10,000 toward the outstanding loan balance.
Yes.
But you are still right now encumbered on that loan to the tune of $16,388.
Yes.
And that is the loan for which Mr. Matthews promised that he would repay you.
Yes, correct.
Okay. Judgment for the plaintiff, Ms. Knopf, actually, was there anything else that you were suing for, or was it the bulk of that loan? Your
Oh,
court costs you always get, but was there anything else that he owed you?
yes, but nothing that I had a contract with,
Okay.
so I'm just gonna have to eat that. I'm understanding of that.
Okay. All right. Well, then we would
Unfortunately.
grant though. Who knows? That might be, you spend a lot of money on classes. I always say that. Sometimes coming to court is the greatest lesson you didn't know in terms of that. You get a lot of things out of this. But today, the judgment from the court would be judgment for the plaintiff, $16,388 plus your cost of court. Ms. Knopf, that decision becomes final after 21 days. So you have the right to appeal it. Let's say you think you've made a mistake in your calculations, or there's more money. Mr. Matthews, once he realizes the lawsuit, he can appeal. Typically, to appeal for the defendant requires them to post twice the amount of the judgment or qualify for an affidavit. Ms. Knopf, as the plaintiff, it's only $500 for you. If you take no action, this judgment becomes final and you can then move forward with any method of trying to pursue the judgment against Mr. Matthews. All right.
Okay.
Any questions
Will
today?
will the defendant receive an email with this information or a letter mail?
We're gonna mail it.
Okay, because he jumps addresses very
That's on the
often.
defendant.
Okay.
No, I mean, that's a good question. Good question. What if he has been served and I have proof that he received notice? I even more than know that because he filed an answer. I know Mr. Matthews knows you sued him. I know he has awareness of the lawsuit. The law says that once a defendant knows they've been sued, if they choose not to come to court, they are stuck with an outcome. And if he does not have an address that we can use because he's not updated it, he may never get a copy of the order. That doesn't make it invalid.
Okay.
People change addresses a lot. Those debts still exist, right? It may be he finds out and then he's like, hey, how come no one told me? And we say, well, because we didn't get a good address for you.
Got it.
But legally, your claim is valid and sufficient, and you've won today.
Wonderful. Thank you. That's the first good news I've heard in a long time. So in terms of collection, the next steps?
There's many ways that a party who wins a lawsuit in Texas can attempt for collection of that judgment. And if you go to our website, there's a section on the left called Helpful Links and Resources. And on that page, there's things about small claims. And the phrase that you might want to write down is post-judgment collection. And that's the legal phrase, because today you got a judgment and you're looking to collect post-judgment, meaning after the judgment, how do I collect my money? And there's different methods you can go about trying to do that.
Great. Well, thank you very much.
Good luck, ma'am. All right, with that, all parties to that matter are excused.
Thank you. Appreciate your time, Your Honor.
Thank you.